Brian Parker here, another video. Actually, this video came from the same place as a couple of the last ones. We did a question and answer session from collectionstoppermembership.com. It was my first, so it was kind of clunky, but there were some good questions. And one of the questions was, Midland Credit Management is on my credit, but I don't have a debt from them. Should be them. And receive no letters. What can I do? Generally, Midland Credit Management is pretty good about sending people letters. But again, it is old and bad debt, and the addresses may be wrong. But if you're not receiving letters from Midland Credit and then something ends up on your credit, something's awry there, because they are, I don't want to even debt collector praise, but they are kind of on top of things because they run a mill and the machine is constantly being updated. Heck, their name is even updated. I used to sue them in big class actions under Midland Funding, and out of the blue they just changed to Midland Credit Management, so I always gave myself credit for that. Anyway, so what do we do about something that's on our credit? First of all, as I preached in many other videos, it's all about attitude. And I'm going to give you a great pro tip at the end of this video, and I'll try to go quick. But when we receive a collection communication from a debt collector, that initiates certain rights that we have under 1692G. And you're entitled within 5 days to receive all your rights to dispute, manage, verify the debt, and essentially say, and the rule is, do you have the right person, and why are you pursuing me? Prove you own the debt. So that part of it is easy. What's hard is getting debt collectors to believe that if something appears on your credit report, that is initiation under the FDCPA, the Fair Debt Collection Practice Act, and therefore the 5-day window starts. Why are they on your credit in an account in a section that says collection account? Because they're collecting a debt. So it is no different than calling me or writing to me and then placing something on my credit. That's an initiation of a collection attempt. So therefore, their 5-day window starts. I argue, and I think the law protects me on that. So I tell my clients where this happens to send out your dispute letter. Even if they haven't given you the rights, they still have the requirement to respond to a validation request, even if they didn't meet their side of things. Understand that, and this is a myth that is even on the internet, if you send a validation request, verification, and they don't respond, that is not a reason to sue them. The only reason you sue them is under the other part of 1692G. So 1692GA is the initiation 5-day window. GB is the statement that if you send a written request for verification to a debt collector, they must cease and desist. It's only if they ignore that and still continue the collection do you have a right to sue them for not responding. So keep that in mind here, because I got a cool way of getting around that. And so once they've ignored the 5 days, obviously they have, if they put something in your credit and you look up your credit, because usually that stuff happens 30 days later, and you say, oh, 30 days ago or 60 days ago, Midland Credit was pulling my credit. Midland Credit pulls your credit. Maybe that's why they changed the name. But you have the right to know why you're being pursued and why something's on your credit. So keep in mind that pro tip I was telling you about when it comes to permissible purpose, the permissible purpose doctrine. How you generally handle disputes is under what's called the FCRA. So Midland Credit operates under the FDCPA. That's another clue there for that great pro tip that's coming. So how you dispute under the FCRA is you send all three credit reporting agencies, TransUnion, Experian, Equifax. Commonly, clients will see something because they have a measured or limited service to check their credit and see something on TransUnion and just send TransUnion the validation or the dispute letter. Excuse me, not the validation letter. Well, belt and suspenders is my rule. Send more than you need to. And the more that you need to send, the more the extra expands into how they must respond. So I want your dispute letters to be full. You want to add your own affidavit, fine. I would take a page of the credit report that shows the debt that you question and circle that and add that to your package in your dispute letter. Also, add a copy of your state ID, add a copy of an envelope with your current address, or even one from a year ago so they can show some permanency if somebody's coming after you at a different address. And that'll force the credit reporting agencies to immediately update. So you want your dispute letter to be full, more than what is required. And if you're sending it to a furnisher of credit is the person that gave you the credit, send it also to the three credit reporting agencies. It's a belt and suspenders move I always require for my clients. Do more than required. If it's a furnisher case, send it to all four or however many creditors you're objecting to. But keep a paper trail, register by mail. You don't know how many times my clients have been saved when they've got this thing that they kept and the signature card saying the creditor got it when they're claiming they didn't. So understand there's a difference between furnishers and the big three, the credit reporting agencies and the furnishers. Who you send that dispute notice to triggers certain responsibilities. I say send them all everything. If you send something to the big three, but not the furnisher, they are legally bound to contact the furnisher to do the proper investigation. Don't depend on anybody to save you. You're on your own in this world. So use the law, but give it more assistance and add your stuff to it. Do more than you need to when you do these letters. And remember the pro tip too. We are seeking a correction of this trade line that this lady is complaining about. There's a cool thing you can do, a down and dirty tip that I will kind of regress to. When you are disputing a debt under the FCRA, you are saying, and rightfully so, that debt doesn't belong in the shape and form I'm disputing. A FICO score, which are the numbers that are created, in this world, everything is, hey, how'd you like that movie? It was 8 out of 10. How was that date last night? 1 out of 10. Okay? She was a 10 and I was a 1. No, I'm joking. But we grade everything with numbers. Those FICO scores are the grades on you that furnishers look at before they give you credit, or if they give you credit, at what interest rate. If you're disputing a debt and all the debts make up your credit report and history under the FCRA on the credit reporting agency's website, the credit report history on you, if it is disputed, it should not be part of your FICO score. What if you're 100% correct? So you will see on your consumer reporting report, consumer disputes. When that occurs, when you dispute and you've just gone into a car dealership to buy a car, for example, that disputed debt should not be part of what makes up your FICO score. You're usually doing it because it's causing you some negativity and it's lowering your scores. If you're disputing, credit reporting agencies have 30 days to fix, confirm, delete, and you got to give them their 30 days. They even have the right to ask for extra days if they communicate with you. But during that interim, your disputed debt is not anything other than disputed. So it shouldn't go into the FICO score. Right? So that's a little down and dirty tip. That's the law. Just saying, not telling you how to get around anything, but if you dispute something, it can't be in the mix that is your credit score. So we'll get into the down and dirty, lovely tip I want to give you. Pro tip. There is a doctrine called the Permissable Purpose Doctrine. As I said before, dispute letters require you give the credit reporting agencies and the furnishers that you're really complaining about 30 days to fix, confirm, delete, do whatever you need to do, even if it's changed the address. You can't sue them until they've done their investigation, and if only then you believe they improperly or did not do any proper investigation. If something like MCM is on your credit and you believe it doesn't belong, like this lady said, I have no credit cards, I haven't had them, there's no reason. MCM, I believe, collects a lot of Citibank and Credit One debt, and she had none of that stuff. So the issue is, what's that doing on her credit report, and is there a permissible purpose? The Permissible Purpose Doctrine under the Fair Credit Reporting Act under U.S. Code 15 U.S. Code 1681B, and that's the Permissible Purpose Doctrine. There's 6 ways people can contact your credit card. Your credit, I'm sucking at this today. If you're applying for new credit, you gave authority. Collection actions, if they're correct. When you seek insurance, insurance companies use your credit report to increase or decrease your scores and the amount they charge you. Court-ordered reasons. A court with the right reasons can order your credit report be looked at. And again, that has to come in the form of something official on your credit report. Or if you apply for a job, every job requires you fill out a credit sort of application now. So if something's on your credit report and it doesn't meet those, let's say 5 or 6 reasons why it's allowed to be on there, you have what's called an impermissible purpose case. You can immediately sue under the FCRA. You don't have to give them that 30-day window to figure out what they did is wrong. There is no dispute requirement, but belt and suspenders, Parker's belt and suspenders again, I have my clients send a letter, a permissible purpose letter saying, hey man, why are you on my credit? And in 30 years of doing that, I have yet to see anybody, any business, come back and go, whoops, you got us, whoops, we're sorry. And when it stays on your credit report, you have an automatic lawsuit. You don't have to do that letter, but I do it as a belt and suspenders. So when you appear in front of a court, you can show good faith and say, Exhibit 1, Your Honor, is the credit report. Exhibit 2 is the impermissible letter I sent saying, why are you on my credit report? And Exhibit 3, Your Honor, is my credit report still listing this and my FICO scores are down. And by the way, this company did not respond to my reasonable request. So whatever way you use, you must have a belts and suspenders approach to add more than the law requires. You must register by mail, keep a paper trail, meaning have copies of everything you sent, have copies or the actual green card that was signed for. It saves you, trust me, been there, done that. Here comes the pro tip. What I do, and I'll attach the letters to this video on my membership site, I combine the FDCPA and the FCRA to help this lady with her letter, with her case. Because if something's on your credit report and it shouldn't be there, instead of sending the dispute letter that's going to add 30 days and they can do what they do, I send a validation letter with an impermissible purpose language inside the letter, and I'll attach it again on my membership site. So you can double whammy slammy them, meaning if they, as we talked about earlier, legally ignore your validation request, which they can unless they pursue you again without properly validating, then that's the violation of the FDCPA. I throw in the impermissible purpose question, like, why are you on my credit? bringing in the FCRA. So they are double whammied either way. If they ignore you and it stays on your credit report, well, you asked, you now have an immediate impermissible purpose doctrine lawsuit. Also, under the FDCPA 1692E8, specifically, that statute, I'm going to read it. It's a violation to communicate or threaten to communicate to any person, any credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. Remember we talked about the ramifications of a dispute? Here's another little ramification. If they blow you off, because all my validation letters say, hey, I dispute this, and if they blow that off because they're blowing off the validation, 50% of the time when you send a validation letter, the collector is in a certain stage where they're just servicing the debt for a creditor, they'll immediately send it back, the debt, to the creditor, and they want hands off. They don't want any liability. When they do that, but they've put it on your credit, they are slammed under 1692E8 because they didn't put the word dispute, and they're slammed under the impermissible purpose doctrine by putting it on your credit. And while there is no legal requirement to explain themselves, taking it off your credit would be a good thing to do, which they've just jettisoned the debt back to the creditor and head for the hills. But you've got them. You've double slammed them. This approach and the right facts will protect you against Midland Credit, PRA, Crown Asset Management, LVNV funding. It's funny that LVNV funding, which is, I believe, out of South Carolina, has a Vegas name. It's a casino approach, taking a chance. Well, they take a chance with you because if this happens to you or something's on your credit and it shouldn't be and you know it, you've got them with the Brian Parker approach of belt and suspenders. And I will attach all my validation letters, permissible purpose letters, dispute letters to this video on collectionstoppermembership.com. Thank you for watching the video. I hope it's helpful. With the YouTube, I'm keeping it free, some of this free on YouTube. Like and subscribe. And again, check out my membership site. It's really a great investment. And compared to the price, power pack stuff, and I bundle things. Oh, I also have an ebook. I have an ebook on how to write collection answers to collection, called Writing a Killer Answer to Collection Lawsuits. You can go to my website, collectionstopper.com, or Amazon. Next week I should be dropping another ebook, really cool, and that's Mastering the Fight Against ID Theft, which is similar to this in a similar vein. That's what made me think about this in that lady's letter. Excuse me, her contacted me. So I hope that helped you. I hope it helps you dispute the debt. I hope she give you a little tip out of double whammy these guys, and go forth and be a warrior for consumer protection. Thank you.